Solihull Ltd and Fearn and others.
Good morning.
Good morning, Mr. Heather.
If it pleases your lordships, I appear on behalf of the tenant Vicky Cook
Yes.
in her appeal number 132, and she is the respondent in appeal number 496.
Yes. I can tell you that we have read the skeleton arguments, including the supplementary skeleton that you put in the other day, and the judgment. And we've looked at Hillmi, of course, and the legislation. I hope that you have sorted out between you the order of events, because as you know, we've got an appeal and a cross appeal.
We have, subject to the court's views,
Yes.
The plan is that I will open my appeal. My learned friend Mr. Bates, who is here with Mr. Morris, will then respond and open his appeal, and I will then respond to his appeal and reply to him.
All right.
So it'll be A, B, A, B.
Yeah. All right.
If the court is happy with
Fine.
the approach. Well, my lord, I'm grateful for the fact that you've received the documents. That will hopefully shorten the time I spend on my feet at the outset.
Yes.
I'd like, if I may, in that case, to jump straight to the Companies Act 2006.
Companies Act. Yeah.
Yes. So this is in tab, the first authorities bundle at tab number 1. And the first provision you'll find there is section 43, which we do need to look at on the way through. Section 43 is the current provision which deals with how companies may enter into contracts. And there are essentially two ways. By a company, by writing under its common seal, so there's a sealing method, or alternatively on behalf of the company, by a person acting under its authority, express or implied. And that distinction between by a company and on behalf of the company is important for the purposes of the matters which are before you. Section 43, as you will have read, was not a new provision. There was a similar provision in the Companies Act 1985, and in fact something similar can be traced back to the Companies Acts of the 19th century. But it's necessary to keep that one in mind, because the next provision, section 44, is a comparatively new creature. It arrived in its first incarnation from the Companies Act 1989 by way of amendment to the Companies Act 1985. Section 44, the current form, is broadly similar to the previous incarnation, but contains what could be said to be relaxations in the methods of execution by way of signature. So section 44 is headed execution of documents, and it provides for execution by a company of a document. And there are broadly two methods: by the affixing of the common seal, or by signature, in accordance with the provisions which are set out in the following subsections. The following subsections are subsection 2. We provide that a document is validly executed by a company if it is signed on behalf of the company, A, by 2 authorised signatories, or B, by a director of the company in the presence of a witness who attests the signature. Subsection 3 tells us who are authorised signatories for the purposes of subsection 2. That's every director and the company secretary, in short.
So do you read section 44 too as saying the document is validly executed by a company only if?
Yes, subject to, for example, other statutory provisions, such as section 74 of the Law Property Act. But our case is effectively, section 44 is the principal method. It is a fundamental rule, and if I can put it like this, it does what it says on the tin. This is how a company is to execute documents, subject to one or two other statutory ways of doing so.
Do you get support for that from the opening words of subsection 1? It just says, under the law, a document is.
Yeah,
Is
yes.
Is that the point?
Yes. This is not an attempt at an inclusive definition. it doesn't provide for the possibility of alternative ways. But as you have seen, there are preserved in Section 74 of the Law of Property Act other possible routes. And indeed in Section 47 of the Companies Act, there is provision for powers of attorney. But the principal method is Section 44, which applies in all cases unless you can bring yourself in another. Subsection 4 is where I've got to. It is a deeming provision. It tells us that a document signed in accordance with subsection 2 and expressed in whatever words to be executed by the company has the same effect as if affected under the common seal of the company. So, therefore, the process of signing by 2 authorised signatories or by a director with an appropriate attestation is deemed to be as if it were done by the company under its common seal. Subsection 5, there's an express deeming provision in favour of the purchaser, that a document is deemed to have been duly executed by a company if it purports to be signed in accordance with subsection 2, and there's a definition of purchaser. Subsection 6, where a document is signed by a person on behalf of more than one company, it is not duly signed by that person for the purposes of this section, unless he signs it separately in each capacity. And then 7, references in this section to a document being or purporting to be signed by a director or secretary are to be read in a case where that office is held by a firm, as references to its being or purporting to be signed by an individual authorised by the firm to sign on its behalf. And finally 8, this section applies to a document that is or purports to be executed by a company in the name of or on behalf of another person, whether or not that person is also a company. So you can see from, for example, subsection 8, that the level of formality that is required can be substantial if you have a corporate signatory by an agent on behalf of another corporate body. But that is quite clearly what Parliament intended. There is, as you will have seen, and I won't take you back to it because you told me you've read Hillmi, there is a useful history of the development of this legislation at paragraphs 7 to 12 in the judgment of Lord Justice Lloyd, which for your note, may well be worth keeping in mind. So, Hillmi was a case about a notice under the Leasehold Reform, Housing and Urban Development Act, 1993.
Do you want us to go to that now?
It's probably as good a time as any to go there.
Right.
So that's tab 21 in the first Authorities bundle. This was a claim for collective enfranchisement, which is started by a notice under Section 13 of the 1993 Act. At the time that the notice was given in this case, Section 13 was in a different form from the one that it is now. The form that it was in is set out in paragraph 3 of the judgment of Lord Justice Lloyd. And it made...
That's in fact, that's Section 99,
it is Section 19.
13.
Yes, that's quite right.
Yes.
Forgive me, yes. The notices provision which applied to Section 13 was Section 19 and
Yeah.
Section 5. And it made a distinction between notices given under Section 13 and 42, which are the initiation notices for either a collective enfranchisement, that's Section 13, or a lease extension, which is Section 42. And the requirement was that the notice be signed by each of the tenants, or as the case may be, by the tenant. And then you had this distinction in subsection B, in any other case, be signed by or on behalf of each of the tenants.
Yes.
Now, that distinction has now gone, but it was material in the case of Hillmi because the decision of the Court of Appeal was that Section 99(5) required the notice to be signed by a corporate tenant, and could not be signed on behalf of the corporate tenant. And in that case, only one director had signed on behalf of the corporate tenant of one of the flats, and therefore that was invalid, which meant that there weren't sufficient qualifying participating tenants to sustain the validity of the Section 13 notice.
Was Section 74 of the Law of Property Act referred to at all?
My Lord, in all
I know
honesty,
you were in the case.
I don't recall. I was in the case. My suspicion, having looked again at what was cited and what's referred to, is that it wasn't.
Yes, because Lord Justice Lloyd says at paragraph 7 that before 89 there seems to be no statutory provision as how a company could or should make a document other than a contract with you. But that doesn't seem to be right, because Section 74 has been around for
Yes.
100 years.
Yes. And the best that you can say is that it is scheduled to the Law Commission report. But as far as I can recall, and I think it's over 10 years ago, I don't recall it being discussed.
Right.
I'm afraid. And with the advent of GDPR, my records of that and my skeleton arguments have all been deleted, I'm afraid.
Probably would have been even without the GDPR.
Well,
This length of time.
perhaps not. We did all very enthusiastically go through a process of deletion a few years back, and yes, regrettably, it's not one that I have maintained. So, my Lord, yes, as you have very helpfully pointed out in your message to the parties last week, Section 74 is potentially relevant in a case like this, and yes, on the face of it, not referred to in Hillmi. The consequence of Hillmi, which I don't think I have said, was that Section 36A, as it then was of the Companies Act 1985, was engaged where a company was required to sign a notice itself, and that was in effect the reason why the company's execution of its part of the notice was invalid for the purposes of the 1993 Act. The judgment of Lord Justice Lloyd does give us some useful pointers in relation to interpretation of the provision which is at hand today, Section 44, because the word execution is common to both, and the word document is common to both. And so far as execution is concerned, Lord Justice Lloyd dealt with that at paragraph 28. Rejected a submission that it focused on only documents which were required to be by way of deed. A document made underhand could also be executed. There was also, in the two preceding paragraphs, 26 and 27, discussion as to what is meant by a document. There was a definition in the Companies Act 1985 as amended of what is a document for general purposes, which has not been carried over into the 2006 Act. The limited explanation as to what a document is in the 2006 Act is in relation solely to company communications and wouldn't provide any further assistance. But I rely on the reasoning of Lord Justice Lloyd in that he himself did not have resort to Section 744 of the 1985 Act as to what a document was. He reached the conclusion that a notice in writing that's required by the Act, Section 13 or 42 of the 1993 Act, is plainly a document.
Just for my note, what are the company communications provisions?
Yes, the company communications provisions are in section.
We've got section 1148. But
Section
I don't think that tells you what the company communications provisions are.
Yes. In essence,
you don't need to answer it now, but
yes,
I would like to know.
Yes, it's notices in relation to governance of the company, in communications with shareholders and the like. Probably not paraphrased it very accurately, but we do, I think, have. Yes, we do have copies of parts of the company communications provisions with us.
Well, just tell me what the numbers are.
Yes, so section 1141, we've got service addresses, 1142, 1143, company communications provisions. Section 1143 is headed company communications provisions,
right.
Have effect for the purposes of any provision of the Companies Act that authorises or requires documents or information to be sent or supplied by or to a company.
Yeah, all right, thank you.
So, my submission is that a document, a notice of the kind that we are looking at in this case, a Section 8 notice, or a certificate under the provisions of the Housing Act 2004, are both plainly documents of a kind that can fall within the execution provisions in the Companies Act. You'll note that in the judgment below, Mr. Justice Saini said that there was no definition in the Companies Act regarding what documents are invalid if they're not executed as Section 44 required. And we say about that is a replication of the error which was identified by Lord Justice Lloyd as to categories of document which potentially exist. He said there's no fourth category. The relevant bits of that are paragraph 27 of his judgment in Hillmi. The submission on behalf of the tenant was that Section 36A of the 85 Act didn't apply to the signature of a non-contractual document on the part of the company, but the response to that was that there would be no relevant provision of the Companies Act that applied to that process at all. And at paragraph 27, Lord Justice Lloyd said this interpretation of Section 36A would result in there being four different categories of document made, to use a general word, by a company. Contracts governed by Section 36, deeds governed by Section 36A and Section 36AA, other documents executed by a company governed by Section 36A, and yet other documents made by a company but not executed by a company, which none of these sections would apply. The fourth category would be those documents which it is not natural to describe as being executed by a company. And his lordship concluded that there was no proper basis or justification for differentiating between types of document made by a company other than contracts and deeds for this purpose and in this way.
I know you've made this point in your skeletons. Yes. I've forgotten where in Mr. Justice Saini's judgment he says makes.
Yes.
Says this.
It's paragraph 44 of the judgment below.
Yeah. Thank you very much.
Would you like me to read it?
No. Yes.
in the authorities bundle is a decision of this court in Williams and Redcard. Redcard and Williams in report, 2011 Business Law Reports, page 1479. That is authority for the proposition that when authorised signatories are signing, they don't need to add the words by or on behalf of the company. That was a case where there was a sale of both the freehold of a building containing flats and the sale of some of the leasehold flats that were owned by directors of the freehold company. And it was all dealt with in one contract. And the signature block at the end contained only one signature on the part of each of the directors. And it was contended that that was invalid for the purposes of section 44. But the conclusion of the Court of Appeal in the judgment of Lord Justice Mummery was that the construction of the agreement in question was such that where the seller was defined, including both the vendor Redcard selling its freehold and the individuals selling their leaseholds, and the signatures included those with the use of the defined term seller above their signatures, meant that on the true construction of the document, it was expressed to be simultaneously executed both by Redcard and by the individuals. You can see that conclusion right at the end of Lord Justice Mummery's judgment, paragraph 27. And there is a plea at paragraph 30, which is sadly not found its way into common practice yet. So what you can take from Redcard is that you have to construe whatever the document is and look at who the parties are and what forms of signature, name and attestation appear at the end. Now, where we say that the judge below in the first appeal went wrong is in paragraph 63. Judgment, and that's page 103 of the core bundle. He rejected the tenant's submission. That his Honour Judge Williams, who was the trial judge, had erred in law and misdirected himself by asking the wrong question when he considered whether or not somebody apart from the landlord was able to sign the Section 8 notice, by concentrating on who could sign the notice. Counsel for the tenants admitted that the judge did not therefore ask the appropriate questions, which he said were, one, who did sign the notice, and two, if the notice was signed by a company, did the formalities of the signature on the notice comply with Section 44 of the Companies Act 2006. I respectfully endorse that submission that was made in the first appeal, and I say that the test that should be applied in a case like this is threefold, and it's set out in our skeleton argument, paragraph 27. We say you should start first with who on the proper construction of the notice has purported to execute. Secondly, if on its true construction it was the landlord company, have the
So
requirements.
you start with who on the construction of the notice has purported to serve it.
Yeah, purported
That's
to
not,
execute
that's
it.
not the question who did sign the notice, because if you ask who did sign the notice, it's Miss Miles. We know
Yes.
that.
Yes. Who, on the proper construction of the notice, has purported to execute it. If on the true construction of the notice or document, it was the company, in this case the landlord company, have the requirements of section 44 been complied with? And thirdly, if on the true construction of the notice it was an agent of the landlord company who purports to have executed, is that permissible under the particular statute or regulation which is in question? And what we say is that Hillmi is a rare example of a case where it wasn't permissible under the relevant statute or regulation for an agent to execute. So we say the starting point should be what happened and look at the document in order to construe it. We say it's wrong to start with my question 3. Is it possible for an agent to do it under the particular legislation? Because that stops you from looking any further. If somebody else could have done, it looks at it the wrong way round. When you have a case where a company makes a choice to provide a document which it purports to have executed, Section 44 provides the means of assessing whether that is valid. The company doesn't have to choose that route. There are, as we've already touched upon, other potential ways for a company to act.
When you say if the company makes the choice, who are you identifying as the company for the purpose of the choice being made?
I'm identifying whatever you can infer from the document. So if the document indicates that the company has decided to go down the route of doing it itself.
But in truth, I mean, no organ of the company as such has made a decision. It's the person executing the form within authority that's decided how to do it.
Mm. Well, yes, and if the filling in of the form is done by an individual, but the form says that it's coming from the company, and only the company is the inference that could be drawn, then I would say it doesn't matter.
I'm picking you up on your point that the company has made a choice.
Yes.
That should require some authorised organ of the company to have made a choice, or you appear to be suggesting that that's what's happened. In truth, that isn't what happened.
No, I'm not saying there has been a formal decision, but what I am saying is the employees of the company have chosen to go down a particular route. It may be a simple employee, it may be a managerial employee. Or
so for this purpose, you are attributing the decision made by the person filling out the form within authority, because nobody doubts that they had authority to fill the form in, to the company.
Yes, I suppose I have to do that just from a practical perspective. But I would say it doesn't really matter from a internal process view how I get to that particular aspect of my submission.
Well, hang on, I'm not sure that I entirely follow this. You agree with Lord Justice Snowden that you are attributing the act of the person filling out the form to the company. It is the company filling out the form.
No, not in a formal sense, no.
Then I haven't quite understood what your answer is.
point which I'm trying to put across is that the notice that we're looking at, the Section 8 notice, on its true construction, we say, comes from the company. That's the interpretation which we say should be put upon it, because the giver of it is identified as the company, and the suggestion of agency, because there is a provision within the form for signature by an agent, is expressly disavowed in that it is crossed out. So it purports to come from the company and only the company, not from an agent on behalf of the company.
The reason I picked you up on it was that you in saying that the correct approach is to start with question 1, I think, is because you say, well, the company has made a choice as to how it executes the form. That was your starting point. And I was picking you up on that metaphysical assertion.
Yes.
And in fact, what you're saying is the form has you simply look at the form and see what appearance it has.
Yes. Yes, that's a much better way of putting it. And looking back at my skeleton, paragraph 28, what I say is when a company chooses to provide, I'm not suggesting, and I didn't mean to suggest, that this company had, by any form of process, made a choice. That's simply not in evidence.
Because the whole point of a lot of the changes we've looked at that led to Section 36A and Section 44 is to do away with the notion or the need to investigate the inner workings of companies when you're dealing with contracts, documents, and the like.
My lord, yes. And the submission on this side is that that's almost the primary purpose of Section 44, which is to enable the recipient to identify almost on the face of whatever the document is that it is valid.
But you accept it's not, in fact, to take you back to an inquiry as to the company making a particular choice in some metaphysical way.
No,
it just doesn't.
No, I stepped back from that wording, which was obviously not quite an accurate formulation. But if we look at the notice, which we've not looked at yet, it's in the supplementary composite bundle at 6, tab 6. And we could probably go straight to page 48, which has got section 6 of the form. So, name and address of landlord, we've got the name of the company, and then we have the direction to be signed and dated by the landlord or licensor, or the landlord's or licensor's agent.
So pausing there, the name and address of the landlord is correct.
Yes.
It's to be signed and dated by the landlord or the landlord's agent, and it was.
So,
It was signed by the landlord's agent. So that bit of the form was complied with.
yes.
Yes. So when it says please specify whether, which sounds like an invitation or a command, it's the crossing out of the wrong bit that leads to the to the invalidity. And that's the short point, isn't it?
Yes, but on its face, this document is not coming from an agent.
Is that fair? I mean, I quite follow that the signatory has described themselves as the landlord, but necessarily they must be an agent of the landlord. Since the landlord is a corporate entity, an individual signing for the landlord must be an agent of the landlord.
Well, my lord, subject to questions of how they were appointed, yes, at a simple level, that is right.
I mean, if they thought they could sign for the landlord, they must, in some sense, have been an agent for the landlord.
But what you don't know, what you don't see from this squiggle, and I mean no disrespect to the signatory, it is not obviously the signature of an individual. It could be an attempt at writing the name of the company. That's.
But the person who writes the name of the company must be an agent. I mean, the authorities make the blindingly obvious point that a corporation does not have a hand to pick up a pen.
So yes, so at that level, yes, there is an agency going on. But the document disavows that it is given by an agent. Yes, the hand holding the pen is the hand of an agent.
It would be quite odd, wouldn't it, if somebody who was an agent chose to describe themselves as a landlord, and therefore there was a requirement for two signatories when one is fine. It's all a bit odd.
Well, that then takes us back to a decision-making process within the company or by the employees of the company. Yeah. Somebody took a decision here. It hasn't been explained, but they took a decision that it would be not Miss Miles for and on behalf of, but it would be squiggle, landlord preserved, everything else, including agent crossed out, and then the name of the landlord company.
I mean, Miss Miles is an employee of the company, so presumably she thinks she's part of the internal machinery of the company, and therefore when she signs, she is signing as the landlord. But that doesn't mean that she isn't also signing as the landlord's agent, because if she weren't the agent, she couldn't sign for the landlord. And if she's signing as a landlord's agent, well, where does sections 44 come into it?
Because we say this is not an attempt at a notice being given by an agent.
But there's, you said a moment ago that the document disavows that it's signed by an agent.
Yes, I do. Yes.
And I think your choice of phrase probably followed on a little bit from the previous questions I asked you. But in truth, the document doesn't disavow. What's happened is that somebody who is an agent has authority to sign, has, on your arguments, done something that they don't have authority to do, which is to invalidly cause the document not to be executed on behalf of the company. They have the authority to execute the document and fill it in correctly, but you're saying in effect they have, quote, made a conscious disavowal of the appropriate way to execute the document within the scope of their authority.
Yes.
Why should the law assume that that's what's actually happened when the agent has filled the form out?
Well, the court should be cautious about inferring too much into the authority. The authority point came up, as you'll have seen in the first appeal, at a rather late stage. And in fact, it didn't really come up in those exact terms, because the way it came up was because there was confusion at first instance as to who had signed this notice, and His Honour Judge Williams had thought it was a director, which...
Well, that's partly because of the way the defence was pleaded. The defence didn't take any point about authority. All it said was you haven't complied with the formalities of section 44. It didn't say, and you weren't authorised.
Well, it raised the question of authorised signatories for the purposes of section 44. It's paragraph 7bc of the re-amended offence. So the question of authority for the purposes of section 44 was in issue.
Well, the question of the formalities. It was quite obvious there weren't two signatures.
Yes.
You don't need to investigate who was authorised to do what. You just count the signatures. There aren't two of them.
And what appears then to have happened is the question came up before Mr. Justice Saini, who, as you will have read, gave permission for a witness statement to go in, which included a paragraph about authority as well, which, as far as I know, was the first time that the question of authority was put down in writing by anyone. So authority has not been explored in any way by anyone.
It's never been challenged. Can I just come back to another point that you made? You said this is not an attempt at a notice being given by an agent. But as I read section 8, a notice can't be given by an agent. It's got to be given by the landlord. The form permits the notice to be signed by an agent, but whoever signs it, it is given by the landlord, is it not? That's the point that Lord Justice Stanley Burnton made in the Newbold case, which is referred to in Ealing.
Yes.
If I ask my personal assistant to type up a notice and put it in the post, I'm giving the notice. Same is true if she signs it on my behalf. I'm giving the notice.
Well, my lord, unless you're a company, right? That is, I would say, the important distinction. Right. And there are provisions relating to documents for companies in the 1925 legislation and in the 2006 legislation, and they do, in my submission, make it clear what has to be done for a company to execute a document.
Right. So, do you say then that this was not a notice given by the company? Is that
Yes, because it wasn't properly executed.
because it wasn't?
Because it wasn't properly executed.
Yeah.
But Miss Miles had authority to sign notices such as this. She says so. She signed in the name of the company, but plainly she did so as an agent of the company, on behalf of the company. So she signed as the landlord's agent.
Well, say that one then enters into the territory of section 74 of the Law of Property Act, because it is not before the court how, if at all, she was formally authorised.
It wasn't challenged.
Well, my lord, in my submission, that is a harsh point to take against the tenant, given the stage at which the point was raised. It was strongly resisted, as I read the judgment of Mr. Justice Saini, that the witness statement should be admitted. It was argued for the tenant that effectively the matter should be remitted in relation to those issues, but Mr. Justice Saini let in the witness statement, which was, as I read his judgment, supposed to deal with the question of who had signed the notice, but had then gone on to deal with that further bit about authority as well. So there hasn't been any opportunity for the tenant to challenge that properly.
There's no reason to doubt it, is there? I mean, well, where would Section 74 take one in this context? She's the property manager. She says she's employed to do these sorts of things. Well, that makes sense.
Because Section 74 contains provisions which regulate how an agent executes documents on behalf of the company, and how they are to be appointed. So if you, it's the first tab, maybe number tab 31 if you're in hard copies of the Supplemental Authorities bundle. So subsection 2.
Sorry, which tab? 31, did you
It's
say?
tab 31, yes. The board of directors can, by a resolution or otherwise, appoint an agent, either generally or in any particular case, to execute on behalf of the corporation any agreement or other instrument which is not a deed. And I say that is potentially of significance in a situation like this, because Miss Miles, if she were to be executing Section 8 notice on behalf of the corporation, would need to be able to point to a resolution or something like a resolution from the board of directors.
Well, a contract of employment might be good enough, mightn't it? If she's employed to be the property manager.
It could be. It depends on the terms, and we've not seen those. And it can be a general authority, or it can be a specific authority.
And if a document is executed, or instrument, to use the words of Section 74.2, if such an instrument does comply with Section 74.2, is it an instrument executed by the company?
Yes, I would suggest it probably is in those circumstances, yes.
Sorry, can I intervene just for 1 second? I thought Section 74.2 is dealing essentially with how people are authorised to execute on behalf of the company. I mean, there's quite a lot in the Law Commission report and actually in the consultation paper about the interrelationship between Section 74 and what we now have as Section 44. But I have to say, I mean, I at the moment read Section 74.2 as dealing with internal manners of authorising people to execute on behalf of the company. Those are the words in the middle. Various instruments and deeds. So the question you've just been asked, does it have the result that compliance with whatever the mechanism has been internally results in the document being executed by the company, is quite an important question or concession or otherwise that you've just been asked, because that would cut across, wouldn't it, the distinction you urge upon us from the start.
Yes. Well, 74.2 is, as my lord has pointed out, on behalf of corporation. And I suggest that the manner of executing would most likely be, in those circumstances, be expressed to be signature on behalf of.
Yeah, the distinction is, I mean, amongst other things, you can see from 74.1 that to be executed by the company, in those days you have the seal.
Yes.
You know, it's the distinction that we actually see in Section 44, I think it is.
Yes, it's in 44. And
so in other words, the seal is the notional, fictional signature of the company, if you will, i.e. something which causes the document to be executed by the company. That the alternative method of execution is on behalf of. But then the changes that were made give you a second way into executing by a company, but without using a seal.
Yes.
The whole point of it was to do away with the need for a seal.
That's it. That's exactly how Section 44 works.
Yeah.
In my
Just,
submission.
just briefly, by way of tangent, I did a word search on 74.2 with the Law Commission report. Doesn't feature
No.
at all.
No, it's all 74.1, which is
Yes.
that they discussed. But yes.
Well, I did something similar, and the main textbooks don't mention it. There is I think a one sentence reference to it in Roth and Roper, which spells out Roth and Roper.
Oh, right.
I think from memory. I mean, it was so much just a restatement of what the subsection said that I didn't even consider.
But that would be consistent with the focus of the Law Commission being on 74.1, which is execution by a company, which requires a seal, and can we get away from that, and etc., etc., etc. Nobody paid much attention to 74.2, because that's all dealing with how you authorise people to execute documents on behalf of, i.e. it's all about authority.
Yes.
Well, it's also not concerned with deeds.
No, it's not deeds.
Because the focus of the Law Commission was on deeds. It may have gone wider, but that's where it focused. Whereas Section 74.2 used to say, being an instrument not under seal, and now says which is not a deed.
Yes. I pray and aids 74.2 in answer to the suggestion that it will make things very difficult if, when companies want to give notices, they either require a signature with an attestation or two signatures. But the existence of 74.2, which has always been there, does enable a property manager of a company like this to be given authority.
In your case, that isn't true with the confirmatory certificate, is it?
It's not true that
With the confirmatory certificate, you say it has to be given by the company. Therefore, it has to be two signatories.
Yes, it would have to be two signatories. For the
Or a
purposes of
direction in
Section
the presence
44.
of a witness.
Or attested. Yes, Section 74.2 probably wouldn't cover that, but it would cover the Section 8 point. But yes, so the significance of 74.2 is that it avoids the difficulties which are advanced on behalf of the landlord with having to comply with Section 44 and straightforward landlord and tenant notices.
But going back to the point where we came into all this, the basis for your entire argument on the Section 8 notice is that you have an agent authorised, or can be assumed to be authorised, who can give on behalf of the landlord the Section 8 notice, who does, within the scope of their authority not challenged, sign the notice. And the whole case turns upon the fact that they, as my lord said right at the start, they crossed out the wrong bit of that line.
Yes.
You say that leads to the conclusion that the company disavowed the intention to execute by its agent and must be held to the higher strictures of Section 44.
Well,
So, and it's been put in that position by the very act of the person that it did authorise to sign the document on its behalf, which was perfectly legitimate for it to do.
well, my lord, you put it as the company or the person's crossed out the wrong bit. That has never been advanced on the part of the landlord. It has never been suggested by the landlord that this is a mistake.
No, well, I don't want to characterise them. Well, okay, that they crossed out the bit which you say leads to the consequence that by the act of the agent, they had in fact turned this document into a document which could only validly be executed by their employer, and hence brought in the requirements of Section 44, something which it would be surprising if they'd have been authorised to do.
Yes, I mean,
As opposed to signing the document validly.
yes. You may have spotted that the landlord in this case is itself a lessee under an agreement which is found in the supplementary bundle. It's called the Guaranteed Rent Agreement. It's actually an agreement for the letting of a furnished dwelling between the...
Sorry, where are we going?
This is tab 2 of the supplementary bundle. It's an agreement between Mrs. N. Ahmed and the landlord, in this case Northwood Solihull, for the letting of 48 Gilliver Road for the term of a year. So this is the superior lease. And if I could draw your attention to the execution provisions of that, page 27. You've got what looks like Anne Brown's signature, the director, and it's for and on behalf of Northwood Solihull Ltd, the tenant. The landlord obviously had some understanding of the way that execution of legal documents should be carried out when a corporate body is involved. They got it right in relation to this. It's not a point that's going to change the whole colour of the case, but when we come back to the Section 8 notice and we look at how it has been crossed out, and you couple that with the fact that it's not suggested that it's a mistake, you have, in my submission, a conscious decision to give the notice in the name of the company and to sign it or execute it in the name of the company.
But does that not necessarily imply, additionally, execution by an agent on behalf of the company?
It does, in the sense of someone has to hold the pen. I can't get away from that. But the tenant who receives this Section 8 notice is going to look at it, and my submission would be they would look at it, they would see at the signature block their landlord's name, the company, and they would see above it a squiggle. And they would conclude that that was, if I can put it in colloquial terms, the signature of the company.
But how could they? If the company can't sign. They must surely conclude it's an agent.
Well, yes, and then we get on to the metaphysics of it. But in simple terms, the assured short-hold tenant will see the landlord's name and the manuscript squiggle, and will assume that that represents the stamp, the mark of the company. The company is bringing this into effect. It could be different if somebody's name was spelled out clearly and you had the words for and on behalf of. But as the common law cases, which I've not taken you to because they've largely been superseded by the Act, but Redcard and Williams also shows us you do have to construe the document.
I mean, I quite follow. If the law is the law, there we are. But there's no reason why one should insist on double signatories in this context. It's perfectly good from a tenant's point of view to get something in this form that alerts them sufficiently to the prospect of proceedings being brought.
Well, yes, but save that Section 44 does what it says on the tin. That's another way of phrasing my Lord's point. Parliament has decided that that is how documents should be executed by a company, and we can't get away from that in my submission.
But if that's not really a question for Section 44, it's a question for Section 8.
Well,
and the question then would be, well, suppose it's not executed by the company, is it nevertheless substantially to the same effect? Not form, effect.
well,
And then you have to ask yourself, well, what is the effect of the Section 8 notice? Answer, it's to warn the tenant that possession proceedings may be taken, to give the tenant an opportunity to clear the arrears, and all that was given to the tenant by this piece of paper.
yes. Well,
Served by the landlord. Not signed by the landlord, served by the landlord.
my Lord, we then come on to the point, well, suppose that it's not validly executed for purposes of the Companies Act. It's in effect unsigned. And my submission, which I draw upon the decisions of this court in Stidulph and Devlin is that an unsigned notice is not valid.
An unsigned notice?
Is not, an unsigned Section 8 notice is not valid. Now, Stidulph proceeded on an assumption that that was the case in relation to a notice under Section 25 of the Landlord and Tenant Act 1954, but did not decide it.
All right. So take the case of a landlord who is a natural person, not a company. So let's leave Section 44 out of it. The landlord turns up at the door of the property with a notice, hands it to the tenant, saying this is a Section 8 notice, and it's not signed. You say that's invalid?
Yes, my Lord, I do. This is, a Section 8 notice is a formal document. It is the landlord vindicating its proprietary right in the property and its contractual right to bring to an end, subject to the intervention of the court, a tenancy. So I say it is right that such a document is signed by an individual landlord, and I say that it is right that if it's a corporate landlord, that it should comply with the formalities requirements of the Companies Act. It would involve...
That begs the question, why can't it be sufficient if it complies with the common law and authority and how companies are authorise people to do things? Why do you say it has to be in compliance with the Companies Act?
Because I say that, in effect, all of those common law decisions on authority are now subject to Section 44.
But you're not saying companies can't validly act through agents who act other than in accordance with Section 44. It all turns on the question of whether it has to be, quote, by the company as opposed to on behalf of.
And you then come back to the method of authorisation and Section 74 of the Law of Property Act, which we say is the route by which an agent could be appointed in order to give a Section 8 notice.
Yeah.
The original forms go back to 1988. The original form regulations were created in 1988. They're not in the bundle, but of course that date is significant because it is before the Companies Act 1989 came into play. The signature block was different from the one that the most recent versions have used, in that there were separate signature blocks for the landlord and the agent, which were set out in full space for the agent to fill in its name and to sign it. So there were alternative blocks. But the point remains that the forms predate the changes in companies law that originated in 1989. And I would suggest that nobody has actually cast their mind over them with a company's law hat on and thought to themselves, well, hang on a minute, these need to be changed. Such changes have been made in other contexts. For example, the Land Registration Act, various forms which are made pursuant to the regulations have been amended to provide for execution by a company with either two authorised signatories or one director with an attestation. If it helps for your note, you can find those in the Land Registration Rules 2003, Schedule 9, Forms D1 and 2, by way of example. Yes. Very great. My learned junior has, by total coincidence, got a copy of the original Forms regulations with him, and I can hand them off if it assists to
They're
see.
in the back of McGarry, aren't they?
It is, yeah, in the back of McGarry.
Yeah.
And they are available on gov.uk. There's- So you probably won't be able to see, but we've got the signature provision, signature for the landlord, name of landlord, address of landlord, and telephone number, and then if signed by agent, name and address of agent, telephone number and date.
Yeah.
So how are you saying, what do you say is the only correct method of the landlord executing or signing in its box? You say there's a separate box for landlord or for landlord's agent.
Yes.
So just, you're giving advice to your corporate client now. He says, I want to execute that first box. I want to use the first box, not the second one. How does he do it?
I would say 2 authorised signatories, and it would involve you coming out of the box effectively. You'd have to probably do
No, it
so.
wouldn't, with respect, because you just told us this is before,
This is before.
the changes.
Oh, I'm so
you'd
sorry.
have to say you've got to
misunderstood
seal
the
it.
question. Well, this is okay. So this is the point, that it seems that prior to the 1989 amendments, the common law position would have permitted a single signatory of this notice, a notice such as this.
Right.
And
So far from liberalising things, the changes have actually made things more difficult.
it may be an unintended consequence of Section 44, yes, or Section 36A initially.
So why do you say pre-1989 a single signature on that form would have sufficed?
Because the provisions of Section 36A were not on the statute book, nor was there anything like them, which says how a company executes a document.
Correct.
So one would look at the common law position.
And what would you have discovered? You'd have discovered you had to affix a seal, surely.
I'm sorry, my lord.
I'm sorry, wouldn't you have then discovered that the only way prior to 1989 that a company could itself execute a document, other than through an agent, was by affixing its seal?
Yeah, yes. So
So if the correct answer to your corporate client prior to 1989 as to how to fill in the first bit of that form would be you've got to use a seal.
you would either use a seal or you would authorise somebody.
Over hundreds of years, notices to quit and all those sorts of things have been invalid when served by landlords.
Well, my lord, it does cause one to scratch one's head a little bit, doesn't it?
It does what?
It does cause one to scratch one's head when
Yes.
one looks at Section
Does
44.
rather.
It does, and I don't shy away from that. And it's not just Section 8. I mean, it's many of the other landlord notices under the Housing Act 1988. But yes,
Common law notices to
some
quit would be the same.
some common law notices to quit as well.
Any contractual notice is probably the same.
Yes.
I mean, a notice to quit is actually more consequence in a way. I mean, that actually terminates the tenancy, whereas Section 8 doesn't terminate the tenancy.
My lord, yes. Probably the reason why it hasn't been a problem in practice is because in many cases an appropriate agency structure is set up either under Section 74(2) or under Section 74(6) in the Constitution.
But if you were right, the many and countless people who would doubtless have just gone to the first of those bits of the form and used the first bit of the form would have given an invalid notice because it wouldn't have been done in the correct form to be done by the company. What they should have done would be to use the second bit, i.e. the agency bit.
Yes.
And that distinction has never presumably surfaced in any case.
No.
Or practice.
My lord, I don't think it has.
Can I just come back to notice to quit for a moment? So if your solicitor sends a notice signing on behalf of the company in the solicitor's name, that's all right.
Well, my lord, the solicitor would have to be formally appointed. Yes.
But with authority, if they write saying, we Blogs and Co on behalf of the company are terminating, that's okay.
Yes.
But if they send a letter in the company's name signed by somebody on behalf of the company, that's not okay. It does not terminate the tenancy.
No, I don't think it would. What I have to come back to is, as I said in answer to my Lord Justice Newey's question earlier, Section 44 does what it says on the tin.
Yeah.
It could not be more clearly worded.
No, we understand that.
Yes, and yes, property lawyers, contract lawyers may well have to scratch their heads and say, maybe Parliament would have to look at it again. I mean, it would be open to Parliament to intervene and to make exceptions for categories of notice, for example. Yeah. But my submission, and I accept it as a strong one, is that it does what it says.
Right.
May I just regroup and see if I miss anything? My Lord, that is for the time being all I wanted to say in relation to the Section 8.
Thank you very much, Mr. Heather. Yes, Mr. Bates. You're going to respond to Mr. Heather's appeal and then open your own.
I will,
understand
yes,
it.
yes.
Yeah.
With any luck, I only hear from you once if I can cover everything.
Well, in theory, you will have a right of reply on your cross appeal.
Yes, we have made provision for that in the time that we've agreed between ourselves, but rather than trying to chop and change between the notices, the reality is the argument, at least at the level of principle, applies to both.
Yeah.
And then we'll explore the facts of each one. So I'll spend more time dealing with Section 8, and then I'll just invite you to read across to the certificate argument with any necessary changes.
Right.
Before I turn to the two notices, can I make three overarching points that will be of relevance to both limbs of my case? I start off by asking us to bear in mind what actually happened on the facts of this case. Well, I'll take you to both notices in some detail in a moment, but when you come to the Section 8 notice, the position is that the notice tells the tenant that their landlord, which it names, intends to seek possession. It's signed by an employee of the landlord who gives evidence that she was authorised to sign that document. And we say, before we get into questions of metaphysics, that's enough. It does all that it's required to do by the Act and the secondary legislation. Similarly, when you look at the deposit certificate, as we'll see in a moment, it's signed by a director of the landlord. Whether you deal with that by saying that is the company acting through its director in the usual way, so it's the company signing, or whether you approach it as a question of agency, doesn't matter. It's sufficient to achieve the purpose for which the certificate is created. But the second of my overarching points concerns the correct intellectual starting point, I suppose, for looking at notices of this nature and certificates. We took issue in our skeleton with the idea that this case involves any question of metaphysics. We say it doesn't. Landlord and tenant notices cases, going back to the early days of the Rent Acts, are intended to be dealt with in a common sense and accessible way, so that landlords and tenants can understand the position without detailed recourse to professional advice.
Common sense, and what was the other adjective? Accessible, was it?
Accessible, yes. So that accessible to ordinary people, landlords and tenants, without recourse to professional advice. And we see that, respectfully, in a consistent line of cases, and I'll just take you to two that are in the bundle. The first at tab 16. Stilldorf, an American school in London Educational Trust Limited case. The American school, as the body corporate, is seeking possession. And what's happened in this case is that the corporate landlord serves their notice to quit, but they fail to sign it. Instead, the covering letter is signed by their solicitors. And the question is that a valid notice? And the Court of Appeal say yes. And the critical part, just to take you to for my short point of principle, at page 112 of the authorities bundle, page 805 of the report.
My authorities bundle, just as a matter of interest, is not paginated, so I'll need the report pages.
It's report page 805.
805, yep.
And it's the third sentence. So long as the envelope contains information which the Act requires and sufficiently authentication of the notice is a good notice. And then the next sentence is the bit we rely upon. The requirements of notice should not be turned into a trap for the landlord.
Sorry, where are you?
Sorry, the top of 805, so long as the envelope contains.
You're in Lord Denny, are you?
I am, yes.
Sorry, I'm not quite sure where I am. So long as the envelope
Yes.
contains, yes.
So long as the envelope contains is his lordship holding that you take the envelope, sorry, you take the notice plus the covering letter, you read them together, fairly unsurprising way. But the point of principle is the requirement of notice should not be turned into a trap for the landlord. And that's why I say there's a long line of cases saying this is not a technical process. This court said
Just pausing briefly.
My lord, yes.
So the form which was required to be used had a signed and a place for signature. Is that
Indeed,
right?
yes.
We see that at 803.
We do.
So in a sense, the form was defective. In the sense that or not the form was defective, but this notice was defective because it hadn't been signed in accordance with the form. But that didn't matter.
Yes, so the form in that case took a very similar form to the form in our case, if you see what I mean. There was a prescribed form, there was a substantially to the same effect provision as well. And the prescribed form had provision for a signature. In this particular case, no one actually signed it, but the solicitors signed the covering letter, dear sir, please find enclosed your notice to quit, etc. And when you read the two documents together, that was sufficient.
In fact, the solicitors signed the covering letter, Bird and Bird.
Yes. Yes. An individual solicitor did not. The firm, Bird and Bird, signed as Bird and Bird, yes.
So, in fact, there was no name other than Bird and Bird who
Yes.
weren't the landlord.
Right. Quite, yes. There's a reason for starting with this one. It's very helpful, as you will see, for establishing both factually, very similar to ours, and also just the point of principle. But just staying with that point of principle about what is the correct approach when considering notices of this nature. It's not just the Stilldorf case that I referred you to. This court last year, in Premba and Lacane, at tab 28, a case again about Section 8 notices. Firstly, are Section 8 notices also a demand for rent? Which the answer is no. And secondly, can they be signed by agents? Which the answer is yes, unsurprisingly. But if you go to paragraph 55,
Sorry, I'm just a second behind you while I was taking the note. Can you give me the tab and page again?
sorry, it's behind tab 28, I'm sorry.
Yeah.
If you've got printed pages in the authorities bundle, it's page 377, but it's paragraph 55 of the report.
Thank you. No, I don't have.
Can I just check, do none of my lords have printed page numbers?
No.
That's helpful. I will stop directing you to numbers you don't have them. This is paragraph 55. Lord Justice Newey making, to my respectful submission, exactly the same point Lord Denning had made some 50 years earlier. These are forms designed to be used by ordinary citizens without the benefit of professional advice. they should be dealt with in non-technical language. There's a related approach as well, not merely the non-technical language, not merely the accessibility, but there's a related point about these notices, that where there's two ways of reading it, one that invalidates the notice and one that validates it, we should take the approach that validates it, that serves its evident purpose. And here, behind tab 25, my lords should have a case called Ealing Court and A1 Freeholds. A case from some 5 years ago where I tried to persuade this court that the notice was invalid for not complying with section 44. And my lord, Lord Justice Lewison, was having none of it for the reasons he gives at paragraph 48. The background to that particular argument starts at paragraph 45 of the report. It's a particular form of notice that leaseholders have to give if they want to take over the management of their block of flats. And as with many of these notices, the secondary legislation dealing with it has a space for signing. And the argument was that a body corporate had signed on behalf of a body corporate, ergo you had to comply with section 44. And this court rejected that for the reasons the upper tribunal had given, which is at 47, where the upper tribunal had held on the facts it was a private individual signing. So it wasn't a question of a body corporate signing on behalf of a body corporate. It was an individual signing on behalf of a body corporate, which was fine. But in addition, my lord, in the second sentence of paragraph 48, makes the point, which I hope is uncontroversial, where you can read a notice as having two possible interpretations, one that serves its purpose and one that doesn't serve its purpose, you should adopt the interpretation that serves its purpose. And that very much came to mind watching my Lord Justice Snowden's interactions with Malone and friends there. Why would an employee of the company have signed a notice in such a way as to invalidate the notice? That goes against the evident purpose of the notice. So we approach it not only from that practical perspective, but we also approach it from the perspective of what is its purpose? Can we read it in such a way as to achieve its purpose? And then the third of the overview points I wanted to make is one again that Lord Justice Lewison was putting to my learned friend earlier, and it does stem from how this case has been pleaded. Can we go in the core bundle to page 175? Under particulars, B in the middle of that page is the pleaded reason why the Section 8 notice is deficient. And the pleading is that it's defective for not complying with Section 44 because, and I'm reading now, it is contended that in accordance with that statute, a document is only validly executed by a company if it's affixed or signed for in the two ways provided by Section 44. So the pleaded case is about form. It's not about authority. And these are two importantly different things. If you want to challenge authority, if you want to say, on the face of it, this is a valid form, but I do not accept that the person who gave it had powers to do so, then that's a different pleading from the form of the notice is invalid. And that's what's pleaded here is form. It's even starker in my submission when you look at how the deposit certificate was dealt with. If we go to page 178, and it's 16b that deals with the deposit certificate. Because the third line down, the pleading accepts that Anne Brown, the director, was an authorised signatory. So no question of authority taken at all. To the contrary, it's pure form. It's section 44 or bust, to put it colloquially. Now, the argument's moved on somewhat, particularly in their note from yesterday. My learned friends now accept that section 44 is not the only way. There would be other ways of doing it, using, for example, the internal constitutional administration of the company to effectively create a scheme of delegation.
There isn't anything in the constitutional documents of the company here, is there? I had a look both at the memorandum and articles as we've got them, and also at Table A, which is incorporated, and I couldn't see anything.
Well, there may well be. If we look at it's in the supplemental bundle.
It's in the supplemental bundle, yeah?
I think it's right, yes. Page 11 in the supplemental bundle for the articles.
Yeah.
Of course, you see 1.1 of the preliminary incorporates Table A. Paragraph 70 of Table A provides for the business of the company to be managed by the directors who may exercise all the powers of the company. And paragraph 71 of Table A provides for the directors to appoint any person to be the agent of the company for such purposes and on such conditions as they may determine, including authority for the agent to delegate all or any of his powers. So Table A may well have been part of the answer had there been a pleading about authority.
Sorry, I've just lost the thread of this debate. I thought the question was directed at whether there's some mechanism other than Section 44 to enable a document to be executed by a company, not questions about how a company authorises agents to execute documents on behalf of a company.
I'm with you on that. I wasn't trying to confuse anyone. I may have failed miserably with that. The question in this case, question in this appeal, is the notice valid? Is the confirmatory certificate valid? And the pleaded case is that Section 44 is the only way to make them valid.
The only way they could be executed by the company.
Yes. Now, to which we say that's simply wrong, and it's the main part of my submissions. Section 44 doesn't ignore the general position of common law, which is that a company can have an agent.
Yeah, but that's the on behalf of.
Yes. But either way, you get to the same result. Because the Section 8 notice can be given by landlord, what? Give me, rephrase that carefully. The Section 8 notice can be completed by landlord or landlord's agent on behalf of landlord. Yeah. The certificate, we say, can be signed by landlord or by agent on behalf of landlord. Section 44 is not the only way for a company to do whatever is necessary to give a valid Section 8 notice or to give a valid certificate. The reason for just going to Table A is I was making the point that what was challenged in the pleadings is form, not authority.
Yeah.
My Lord Lewison put earlier, because had we got into questions of authority, then we'd be looking at different material. We'd be looking at Table A and such like to show how that all works out. Can I start with Section 8 itself, rather than with the Companies Act and my own friend did? And it's behind tab 2 of the authority bundle. I'm sure the court knows this, but of course this is dealing with effectively the gateway to possession proceedings against assured and assured short-hold tenants. This is by far and away the most common form of tenure in the private sector and housing association sector. Section 8 is directed at and always envisages the landlord doing something. It's the landlord giving the notice in 1A. And it's the landlord's intention in 3A, for example, that matters. What Section 8 does in 8.1 is say that there are two gateways to get you into the county court to have a possession claim heard. 8.1a is the giving of the notice. 8.1b is the court dispensing with the notice. Now, I'm not going to come back to dispensation, so I just need to deal very quickly here with two short points. Firstly, we draw attention to the fact you can dispense with this notice, because we say that does indicate that any attempts to raise to elevate the importance of the notice beyond a certain point will only take you so far. Parliament clearly envisages possession claims, at least in some circumstances, where notice hasn't been given. Secondly, and for completeness, when this argument was raised in the pleadings, our reply applies for dispensation, drawing attention, among other things, to the level of rent arrears. Now, I'm not going to ask you to deal with that today, you're not in a position to. But I just raised that because if you're against me and you find this is an invalid notice, it doesn't follow that the claim is dismissed. There is still an extant application for dispensation.
And Judge Williams didn't have to deal with that because he found for you on the notice point.
Quite. Judge Williams didn't have to deal with it, and it didn't arise in the High Court either. For your reference, it's core bundle, page 182. So it's there. I don't want to leave it until draft judgment is handed down, just to raise that there. It's an undetermined issue. 8.3 makes provision for the Secretary of State to prescribe a form of notice. And you see the three things that are set out as being particularly important are that the landlord intends to begin possession on one or more of the grounds. The proceedings won't be given earlier than a date specified. I won't take you through the calculation methods. The different grounds have different date periods and they get quite complicated, particularly with the COVID changes. And then 3C, tenants are told that there's only a 12-month window for this notice. You've got to begin your proceedings within 12 months. The form of the notice as it currently reads is at page 38 behind tab 9 of the authorities bundle.
Yeah, I don't think we've got the previous regulations, do we?
I thought, yeah, my learned friend kindly put them in the supplemental bundle.
Oh, in the supplemental.
So they're behind tab 37 of the supplemental
Sorry,
bundle.
which one? 37?
37, my lord, yes.
That's where you get the substantially to the like effect.
Quite. That's why I'm going to take you to those as well.
In mine, it's behind tab 33. I'm not sure why there's a difference in
Yeah,
numbering.
yeah, I got 33.
33.
Yes.
I think
So it's regulation 2.
quite regulation 2 or form structure to the same effect.
Right, so the form itself is form 3 in the 2016 regulations.
Yes. And the only 2 points I wanted to make about the form are, on its face, it's clearly content for an agent to sign, because we see that in box 6. And secondly, deviations are permitted, so long as it is to the same effect. Now, our notice in this case, we say, is a perfectly fine notice. And in the supplemental bundle, page 46, I'll take you through our notice and explain why we say that. behind tab 6 in the supplemental bundle. So we see at page 46, it's addressed to the tenants. It tells them that your landlord intends to apply to the court for an order requiring you to give up possession of the name of your property. It tells you what grounds for possession your landlord will be relying upon, 46 and 47. It tells you in 47, under the give a full explanation of why each ground, it tells you why those grounds are satisfied. It tells you at box 5 the earliest date upon which they can issue proceedings. And it tells you on page 48, on the last bullet point, that the notice is only good for 12 months. So it meets all the conditions in section 8. Then in box 6 of the notice, it tells you correctly the name of the landlord and the landlord's address. And then it's signed on page 49 by Miss Miles, who we know is the property manager, and we know she is authorised to sign notices of this sort. And for completeness, you find that in the judge's judgment below, that's the High Court judgment, core bundle, page 97, paragraphs 28, 29, 32 and 34, and her witness statement is in the supplemental bundle at page 68. I won't take you to them. You can come back and look at them if there's a challenge to any of those matters. And we also know this notice was served by Amanda Dodd, who is a director of the company. And you find in the supplemental bundle at page 50 a certificate of service.
Sorry, say that again, I didn't
We
catch
know, we know the notice is served by Amanda Dodd, who is a director of the company.
Right.
So you see that at page 50 in the supplemental bundle.
Oh, I see, yeah.
And we say, well, what more do you need to do? It complies with section 8, the 3 prescribed matters. It's in the form that's required. There's no suggestion that Miss Miles or Miss Dodds are going off on a frolic of their own. If somebody had wanted to challenge the authority to sign or deliver this notice, they could have pleaded that. But they didn't. There's nothing wrong with the notice. The argument against us really involves, in my submission, section 44 being a complete code and being the only way in which notices of this sort can be signed or executed by a body corporate.
Well, I thought that the argument against you turns upon the fact that this purports to be a notice by the landlord, executed by the landlord, not by a landlord's agent.
So, the pleaded case is section 44 only, as we saw. The argument put today is to do with the crossing out of the wrong part. That's why I started with looking at the overview of the position on this. This isn't a technical trap. We read it in a practical way. When there's 2 ways of reading it, one that validates it and one that doesn't validate it, we take the approach that validates it. And I'll end this part of the submissions in due course by coming to Manai as well. It's a reasonable reader test, come what may. But the pleaded case is section 44 is a complete code. But if the argument put orally is there's something defective about the notice, that's the answer to it. There's nothing defective about this notice. It's a question of construction. But respectfully, we say section 44 is not a complete code. Companies have the benefit of common law positions as well. And in the authorities bundle at tab 17, we have a Privy Council case called Meridian Global. The facts of this are to do with whether a New Zealand company had complied with certain disclosure duties had as a holder of securities. But page in the report, sorry, page 506 in the report.
Just a minute.
Into
Behind
five-
you. We're going to Meridian, yeah?
I am, yes.
Page 506.
Page 506 of the report, yes, behind tab 17.
Yeah.
And we've set a lot of this out in our skeleton, but the critical part in our submission is on 506B, all the way down to 507F. And can I just trouble the court to cast their eyes over that?
Now, is this part of a submission that what Miss Miles did counts as the acts of the company, or is it part of a submission that acting by an agent is sufficient and that is what Miss Miles did?
So this is the first of those. This is to be treated as the act of the company. And the reason I want this is because I want to show that section 44 is not the complete code.
Yeah.
So, in my submission, what you can see here, at 121B to E, is...
So when you say 121,
Sorry, it's my page number. It's 506
Yes.
B to E. What you have described in those paragraphs are the two primary rules of attribution. So, an act is attributed to a company so that it becomes the act of the company, in accordance with its own internal rules, for us, of course, it's articles, or secondly, in accordance with company law, to which section 44 would be an example. But that's not the only way of dealing of a company, of acts being attributed to a company. F to G on 506. Companies benefit from the general common law of agency. Now, if I need to, I'm happy to say Miss Miles is acting as agent, but that's not why I'm taking you to this case. It's showing you that 44 isn't the complete code. So they have the primary rules, they have the general rules available to everyone. And then there's a special scenario that can only apply to companies. And this is on 507. And at B to C, the board is describing the scenario. A rule of law expressly or by implication excludes attribution on the basis of general principles if the rule is stated in language primarily applicable to a natural person and requires some state of mind on the part of the person himself as opposed to his servants or agents. Criminal law is one such example. So if we have a scenario where we have a requirement that more naturally would apply to a natural person, how does that relate to a corporate person? And then at D to F, the board says there are three answers to that. The first is you might conclude that it doesn't apply at all. So imagine you've got a situation where the criminal sanction is community service. Given that you can't impose community service on a company, you might conclude the provision doesn't apply to the company at all. The second is to say that the only way of dealing in those circumstances is to use the primary rules of attribution. So here, section 44 would be the argument. But the third option between E and F is what the board calls the special rule of attribution for the particular substantive rule. It's always a matter of interpretation. Given that it was intended to apply to a company, how was it intended to apply? Whose act or knowledge or state of mind was for this purpose, intended to count as the act, etc. of the company? One finds that answer by applying the usual canons of interpretation, taking into account the language of the rule and its context and policy. So, as to how a company signs Section 8 notice then, well, it could be under the primary rules. It could be Section 44, or it could be its internal constitution. Or it could be general law of agency. Or it can be the special rule. What does this statute in this context require? And in the context of a notice seeking possession, I respectfully suggest the property manager is the obvious person to be required to turn their minds to this. It makes much more sense for the property manager to deal with this than the ultimate owner of the company.
So you're effectively saying the general law of agency takes care of this situation?
I certainly say general law of agency is part of it. My submission is you don't need to go to Section 44. I'm not saying it's excluded. A company that wanted to use Section 44 could. But Section 44 doesn't exist in a vacuum. It exists against the background of the general law of agency and, if necessary, the special rule.
The general law of agency is this: if I appoint somebody to do something on my behalf, then it counts as my having done it.
Right.
That's the general principle. It's even got a Latin maxim to tell you that.
Yes, agreed. And the general rule applies here in the usual way.
Yeah.
So Section 44, the pleading, just asserting that Section 44 is the only way, is wrong in law. It's always a question of looking at this particular notice, and then there's two ways of dealing with it. On the facts of this case, there's two ways of dealing with it. Either it's the general law of agency. She's the employee of the company and she says it was her job to sign these notices. Why can't that be agency? Or it's the special rule. Look at what the Act requires. Was the Act content to have a property manager sign this notice? And the answer to that is yes. We don't very much mind on this side what the answer is. There may be landlords who have a particular view one way or the other. Our concern is to establish the validity of the notice. And either of those ways, we suggest, gets us home on what we need, which is a valid notice. If we're wrong about that, of course, whether under agency or the general rule, we've touched on it in the skeleton, and you put it to Melanchthon earlier, you get into arguments about substantially the same effect and such like. The information that's required by Section 8 is all in that notice.
Yeah.
So, can I just be clear? So, submission 1 is Miss Miles was entirely entitled to describe herself as the company. Her act is attributed to the company under agency principles. Forget about Section 44.
Agreed, yes.
Submission 2, I think you make, do you? Supposing that to be wrong, the fact is she was signing as agent. That's fine.
Yes.
It doesn't matter that she crossed out that bit. She obviously was signing as agent. Submission 3 is, if both of those are wrong, then you've got substantially the same effect.
My lord, yes. Yes. As is always the way. It's much shorter and more quickly put from the bench, but yes.
But without wishing to overcomplicate matters, if Miss Miles said, I am the company, as a matter of law, that's not the case. I mean, she is a different legal person from the company. If she said, my act is deemed by principles of agency and attribution to be the act of the company, that would be correct.
That is correct. It wouldn't necessarily follow that her incorrect statement of the first kind that you put to me invalidated the notice, though, because it's always a question of construction.
No, but it's just I mean, I fully understand that somebody who acts as agent within the scope of their authority on behalf of a company does an act which is the act of the company, done on the company's behalf. I have more difficulty understanding how one person recognised in law as a person can validly say, I am the other person. This is all about attributing acts,
Yes.
not confusing legal personality.
Yes, I agree with that, yes. And what we're looking at, respectfully, in a Section 8 notice, is we are looking at, does it comply with the requirements of
Yeah,
Section
no,
8?
I understand that.
And this is why you may have seen the skeletons. We approach this in a very different way. We relegate the Company Act to almost insignificance in the way we approach our submissions, because we say this is the wrong way of looking at it. You start with Section 8.
But your major problem, which obviously you'll come to, in terms of your first submission, is Hillmi.
Yes. Which takes me to Hillmi, if I may. We say there are 4 reasons why Hillmi is not determinative of this case. The first, as my learned friend alluded to earlier in opening, is that it's simply a very different scheme. Section 99 of the 1993 Act, A, had an express primary statutory requirement: the notice be signed by the tenant. It wasn't something imported by secondary legislation. And secondly, the effect of the notices in Hillmi is very different. My Lord Justice Lewison will certainly know, and I expect my other Lords to do as well. But the reason why there's so much litigation, or one of the reasons why there's so much litigation about these initial notices, is that if the landlord fails to respond, and the proposed price is a realistic price, the tenants get it at that price. And generally, that is the lowest price reasonably available under the Act. So one sees, so there's effectively there's a very different context to what the notice is doing and why it matters. Whereas in our case, it is simply one of the 2 ways to get you before a district judge and have the district judge decide what to do. The second point is that it's clear that no one addressed the court on the point I've just taken to you about attribution and the common law position. And we can see this troubled Lord Justice Lloyd, because he refers to this obliquely in a handful of places. If we look in Hillmi, which is tab 21, paragraph 6 on page 2573 of the report. Where he mentions that no one put the company's articles into evidence, which may be one way of having, you could have got round the problem of the Companies Act, looking at section 74. But also, following Meridian, the company's articles would have been a way of having primary attribution. And he comes back to that point at paragraph 20. Because in paragraph 20, you see, he actually identifies that there could be 2 different ways of signing. One is A, to use the body's own constitutional documents. But there's no reliance on that. We respectfully say, Lord Justice Lloyd was plainly aware at the back of his mind that there was something else that might have been relevant to this. But the way it was argued in section 36 and section 36 alone led him to that answer. Hillmi is not authority for the proposition that section 36, as it was, 44 as it is now, is the only way. It's authority for how you use that part of the Companies Act under that scheme of legislation as it stood at the time.
So you're saying effectively that when Lord Justice Lloyd says at the end of that paragraph, the only recourse must be to the general law, you say, well, he's overlooked a very significant part of the general law, namely common law, agency, stroke, rules of attribution?
Yes.
So
We know you overlooked section 74, as did we. But we know you overlooked section 74 because it's not referred to. But my lord, yes.
So if we look on to paragraphs 26 to 28, which on the face of it present your particular problem, where Lord Justice Lloyd says there isn't a fourth category, you say that in the third category, you can use approaches other than section 44, do you?
I do. I also say, you look at paragraph 28, Lord Justice Lloyd is again, in my submission, when you read 28, is again expressing his discomfort, because he comes back to there being a degree of formality required to make the document valid. So his opening words of paragraph 28, he's leaving open a situation where there's a document that doesn't require a particular form to make it valid. And in those circumstances, he's saying, well, what I'm about to go on to explain doesn't apply.
Sorry, I'm losing again the thread. I understand entirely why the memorandum and articles of association, particularly the articles, are relevant to the question of authority, because that's where you will find set out the agreement between the members as to who makes decisions and acts on behalf of the company. And that's all to do with allocation of responsibility, and you bolt onto that questions of agency, either because that's what the articles say or because it's done as a matter of the general law, but that's all to do with agency. I understand section 44, which says this is how a company executes itself a document. It's a statute, it's a legal fiction, because we know that a company is a legal construct, but that's what the law says a company can do, and a company only can do what the law says. A company is a legal fiction. It only has what the law gives it. Are you saying that there's some intermediate mechanism by which the articles could say, well, forget section 44, forget questions of agency, this is how this company can execute a document, other than by agency or what the statute permits? Because if you are saying that, that's pretty revolutionary in company law terms.
No, I'm trying to set out what Hillmi is and isn't authority for. I'm suggesting that Hillmi ignores the possibility of a company's articles making provision for how a company will sign a document. Because remember that the enfranchisement notices have to be signed.
Other than by using a mechanism of authority. If you're saying the articles can set out who will be authorised, or the mechanism of authority, I understand you don't need to go further. If you're saying that the articles of a company constituted under the Companies Act can specify a mechanism other than by the use of principles of authority, other than by use of the statutory provisions that we've seen in section 44, by which a company can execute a document, then that's, I don't follow it, because the company only has the powers that the Companies Act give it, because it's a construct, it's a legal construct.
Right, no, I'm not saying that. No. I'm dealing with why Hillmi doesn't present the obstacle to my case.
So just to understand, if I've got your submission right, you say Hillmi doesn't take account of the wider category of agency, an aspect of which can be the articles.
Yes, certainly. That's the narrow reason why Hillmi is not determinative of this case.
So just to follow up Lord Justice Snowden's question, if we go to section 44 for the moment, tab 1, document is validly executed by a company if it's signed by 2 authorised signatories. Following our authorised signatures, every director of the company Are you saying that the articles could say the office boy is an authorised signatory for the purposes of section 44?
I am saying the company can appoint someone to sign who is not limited to that category in section 44. And you can see that.
As a matter of, sorry, Lord Justice Lewison's, I don't think that's really an answer to my Lord Justice Lewison's question with respect. Do you mean appoint somebody other than those specified people whose signature will have the consequence set out in subsection 4? In other words, it would have to go further. It would be a document signed not in accordance with subsection 2, but because the company's put something in its articles which doesn't comply with subsection 3, but would nevertheless have the effect set out in subsection 4.
I don't know if I quite need to go as far as that, because I would say, for example, section 74(2) is an example of such a provision. It's a provision whereby the board of directors or other governing body may by resolution appoint an agent to execute on behalf of the corporation an agreement or other instrument.
Yeah, but that's execution on behalf of the company, which is an agency point. My Lord Justice Lewison was putting to you, can effectively a company in its Articles of Association rewrite for its own purposes section 44 and achieve the result set out in section 44(4)?
I don't make that submission. But once you get to the agency point, because the act of the agent is the act of the principal, at least in the context of these notices that we are concerned about here, this is now a distinction without a difference. Just one moment.
Well, but that's because you say that the requirements which need to be satisfied are not to be found in section 44 of the Companies Act. They are to be found in section 8 of the Housing Act and the regulations made under it.
Correct.
And there's nothing in those provisions which excludes the application of the law of agency.
Quite, yes. Which is the common law position as well, generally applicable.
But in effect, you're saying this document doesn't need to be executed in the section 44 sense.
I'm perfectly happy to say that, yes.
And then you run into Lord Justice Lloyd saying in paragraphs 26 and 27 there isn't a fourth category.
But then he uses paragraph 28, because in paragraph 28 he envisages a category of documents to which this wouldn't apply. Otherwise, the opening words of paragraph 28 don't make any sense. Just giving a different example. Lord Justice Lloyd isn't considering, for example, how a company signs anything except by executing under section 44. His lordship wouldn't dispute, I'm sure, that companies sign checks and don't do that in accordance with section 44.
No, somebody on behalf of the company signs the cheque.
Well, it
A
may.
company can't sign a cheque.
A company can't do anything. This is the difficulty.
Unless statute, section 44, deems it to have done so.
But even then, the primary act is an individual. The actual affixation of the seal, for example, is an act of an individual.
Can we just pursue the cheque example for a moment? I assume the chequebook would have, I've forgotten the name of this company, Northwood Solihull Ltd. And somebody would put a signature above that. And from the bank's point of view, what would matter would be that matched their authorised signatures. But if the bank's form said one signature was enough, I assume they'd take one signature as sufficient. They wouldn't worry about section 44.
Quite, and it would be an effective check.
Because it wasn't something that was being executed.
Quite. But there are things that are signed that are not executed.
Yeah, and that would be the company's cheque, you say, and it would entitle a debit to be made from the company's bank account.
Quite.
what about notices to quit?
I have never heard anyone speak of executing a notice to quit. One doesn't execute a notice to quit any more than one executes a notice seeking possession.
Well, now you've got a problem with Hillmi, I think, haven't you?
Well, that's why I'm saying Hillmi in this particular context. Hillmi is a different scheme achieving a different purpose. Hillmi wasn't taken to the general law, as Lord Justice Lloyd recognises, and that, respectfully I say, that plainly troubled him, because he returns to it in paragraph 20, having raised it in paragraph 26.
I mean, Hillmi really turns, doesn't it, on the difference between section 99.5a, signed by, and 99.5b, signed by or on behalf of.
Yes.
That's the critical difference.
Yes. And in this particular context, it holds that signed by, where it's a body corporate, required section 36a. That's the holding in Hillmi. That's the very narrow effect of it. It's not authority for the proposition that the only way to a company can ever sign a document is in accordance with section 36a, now section 44. And if it's being read more broadly, that's wrong. It's a case about its context.
Yeah. The contrast, in other words, between A and B in section 99.5 is to exclude agency
Yes.
from A.
Yes. It's not to tell us how section 8 notices are dealt with, which expressly envisages agency. I have just two very short points to end with on Section 8 notice, and then I'll turn to the deposit certificate. All being well, I'll finish before the short adjournment, which I suspect will be a relief to all concerned. The two just brief wider points I wanted to make. The first is we say there is something of an oddity if you can only use Section 44 for your notice seeking possession, because we know that you can grant the tenancy as a simple contract, as long as it's by less than 3 years, it's not by deed. And a single signature would suffice, see section 43. We do say it's very odd to imagine that you can go through the much more important step of creating the estate in land with one signature, but you require two in order to serve a notice, the only effect of which is to entitle you to a hearing before the district judge. And secondly, we end really back where we started by saying that the answer to these cases is primarily a question of construction of the notice. Does it do what is required by Section 8? I drew your attention earlier on to the approach to interpretation in the Elim court case, and I said I'd end with Manai. I just draw your attention. We can do it just for, I suspect, just by reference rather than having to go and look at it. A case called Pease and Carter, behind tab 27. A case from last year, where this court reviewed Manai, the reasonable recipient test applies to notices.
Paragraph 39.
Quite, my lord, yes. The lengthy review, including of your judgment in Fernandez and McDonald, concluding in paragraph 39. I just draw attention to that. I then move, if I may, to the deposit certificate itself. Can we start at tab 4 of the authorities bundle, please? Do I mean tab 4? No, I think I mean tab 5. Sorry, tab 5.
Yes.
So,
can I just get the chronology right here? When the deposit was paid and the purported certificate given, the order in force was the unamended version of the 2007 order.
Correct. The deposit is paid and certificate given in mid-2014, and the amendments are made by the 2015 Act.
Right. So at the time when the deposit was paid and the certificate given, there was nothing in the Article 2, 3 or whatever it was,
Exactly.
wasn't there.
No, quite. I'll come to the article in a minute, but yes, that's right. There's a change made by the Deregulation Act 2015,
Yeah.
and it's deemed to have always been there since tenancy deposit stuff comes into force in April 2007. But if we just start with section 213, the provision relating to tenancy deposits, as I'm sure my lords all know, since 2007 the position has been that where a landlord under an assured short-hold tenancy receives a deposit, he's got to deal with it in accordance with a deposit protection scheme. Broadly, there are two kinds of scheme. There's a custodial scheme, whereby effectively it stays in a third party's bank account. There's an insurance-backed scheme where you buy an insurance policy for the value of the tenant's deposit.
Sorry, before we get to 213, can we go back to 212?
Of course.
212 sets up the scheme,
Yes.
subsection 1, and subsection 9 tells you that in this chapter, references to a landlord include references to a person or persons acting on his or their behalf. So whenever we see the word landlord in this chapter, and it might be argued insubordinate legislation made pursuant to the chapter, we read in the word or a person or persons acting on his or their behalf.
Agreed. Entirely agreed. 2129, we'll come to this in a moment, but 2129 in our submission, you didn't really need to make the amendments they made in 2015. 2129 would have served that purpose. But 213, you see 2131 imposes the obligation to deal with the deposit in accordance with the authorised scheme. And then 2135 sets out what the landlord or the person acting on his behalf, the 2129 point, has to do with that deposit. They have to give the tenant or any relevant person, just for completeness, that's a third party who's paid a deposit, for example, a parent guaranteeing a tenant's rent, that kind of thing. Has to give the tenant or any relevant person such information relating to the scheme, compliance with the requirements of the scheme, the operation of this chapter as may be prescribed. Subsection 6, you have to give it in the prescribed form or a form substantially to the same effect. 6A, 6B within 30 days of having received the deposit. And yes, my lord, as I was going to note, 2129, although it looks from the face of 213 that applies to landlords, it applies to both landlords and anybody acting on their behalf. The information itself is behind tab 10 of the authorities bundle.
Sorry. My 10 is section 79 of the Common Law Resold Book.
There is a problem making these bundles now.
Must be somewhere else.
I've got it sent in. Thanks, Steve.
Yeah, mine.
There was a problem when these were made, and we sent them in late. Clearly they haven't made their way to you.
So we're looking at the Prescribed Information Order 2007.
We are, my lord, yes.
Yeah, that is behind my 10, I think.
To manage.
Yeah.
Thank you.
So, as it stood, my Lord Justice Lewison's point, as it stood when this deposit was received, it was Regulation 2.1, which was the prescribed information. And you see that A to F are all manner of information about the scheme itself. So it's leaflets the scheme produces, it's how you access the end of tenancy dispute resolution service, etc. G is the material, and it's only G, is the material that's going to have to be certified. And it's the amount, the deposit, the address of the property, name and address, etc. of the landlord, name and address, etc. of the tenant, name and address of any other relevant person, circumstances when the deposit can be retained, And then confirmation in the form of a certificate signed by the landlord that the information he provides under this subparagraph is accurate to the best of his knowledge and belief, and that he's given the tenant the opportunity to sign any document containing the information provided under this article by way of confirmation that the information is accurate to the best of his knowledge and belief. We start off by saying, well, firstly, this is like the Section 8 notice. It's a form that's entitled to be in substantially to the same effect. So what matters is the information rather than any particular element of it.
Is there in fact a prescribed form?
No, this is the order.
So the only prescription of form is that it's got to be in the form of a certificate signed by the landlord.
Correct.
Query, or a person acting on behalf of the landlord, see section 2129.
Correct, yes. Now the decisions below focus on the word by in G Roman numeral 7 and effectively say, well, that means personal service only, it means section 44. But we say respectfully, no. Before you even get to the changes that were made in 2015, the governing statute said landlord included anybody acting on their behalf. So the starting point was that landlord included agent.
That must be so from in little double b, 7 little double b, that also talks about information provided by the landlord. I mean, that must mean provided by somebody on behalf of the landlord, i.e. the provision, the act of provision being deemed by a process of authority to be the act of the landlord.
Quite.
Because landlords, corporate landlords in any event, can't provide information other than through authorised agents.
Quite.
Sorry, I wasn't keeping up with my lord there. What was the reference to?
Sorry, just in G little Roman 7.
Oh, I see, yes. Yes.
7 talks about a form of certificate signed by the landlord, but in
Yes.
little double b, which is one of the things that actually has to be certified, is the information provided by the landlord. But, and I think my suggestion was that that must necessarily mean provided through a process of agency on behalf of the landlord, because in the event of a corporate entity, a corporate entity can't actually do the provision of information. It can only be attributed as having done it through the acts of an agent.
Nor can it have knowledge or belief except through an agent.
Yeah. So it's necessarily the section, the thing that is being certified is necessarily something which will have to have been done through an agent.
Quite, yes. 2129 is the gateway to answer this. And the focus that was placed below on the word by.
Well, I'm not even necessarily going to 2129, because if you just look at B and what's certified and what's said to be required by way of knowledge, it's plainly that the reference to by the landlord suggests that it must be by people whose acts are, or knowledge for this purpose is to be attributed to the landlord.
Quite, it's the 2 points. On the construction of the statutory instrument itself, I completely agree. We simply start with 2129 because in the usual way, statute, it's the statute that does the running rather than the SI tail wagging the statutory dog. So we say, just on first principles construction, agent was always going to be enough. We looked at the beginning in the pleadings. It is accepted in the pleadings that this person is an authorised signatory. So when we look at the deposit certificate itself, it's in the supplemental bundle at page 38. One to 6 on 38 marry up to 2A to F in the prescribed order. 7 marries up to G. And one just takes it down through. And on 40 you have the signature. Of A. Brown. Pleading accepts that A. Brown is a director and was an authorised signatory. Whether you deal with that by saying It is the signature of the company because the director is entitled to manage the business of the company.
What about the words "we" being the landlord? Certified. It's not I being an agent of the landlord, it's we being the landlord certified.
Well, it's always a question of construction, so there's two ways of approaching it. Our primary position is that is the signature of the director. It's pleaded, it's an authorised signatory. Companies act through their directors. Why, as a matter of construction, therefore, is that not a signature of the landlord? If that's wrong, there's no reason why agency in the usual way wouldn't apply.
And reverting by Lord Justice to Lord Justice Snowden's point, when you get to little 2, we have given the tenant the opportunity, which is satisfying the requirement that the landlord has given the tenant the opportunity. I'm not sure how you would frame it differently.
Picking up Lord Justice Lewison's point, to the best of our knowledge and belief, presumably must be somebody whose knowledge and belief is to be attributed as through a process of agency to the company.
Yes. Again, it's the same as the Section 8 position. How we get to, as long as we get to the conclusion, we are on this side slightly agnostic about it. We simply set up what the two different approaches to it are.
We don't mind what you decide as long as we win.
It happens so rarely. I would take it by any route, my lord. But simply because it seems to us, respectfully, having looked at the grants of permission that my lord made, it's not simply limited. This court isn't considering this because of the facts of this case particularly. It's the wider implications on this, and that's why I simply set out the two different routes by which one could have come to the conclusion. Whichever one it is in this case troubles us not. It may matter more in one than in another case that it's one rather than the other. But for this case, either will do. There's 3 points just to make to end with, which I will manage to do in the 5 minutes, hopefully. The primary point against us, of course, below and in the skeletons against us, is Hillmi. Well, we've covered that previously. We say Hillmi. Hillmi just doesn't tell us the answer in this case for the reasons I covered. Perhaps more substantively, if one stays in the authorities bundle looking at the prescribed information order, the changes made to Article 2, 3, 4, 5, and then Article 3 that were added by the Deregulation Act are perhaps slightly harder to explain.
You've got to explain Article 2.5, haven't you, which now disapplies Section 2129A.
Despite in 2.3 having expressly authorised an initial agent to act on the landlord's behalf.
Yeah, but the initial agent is not just any old agent. It's got to be the person who complied with the, what they call now, the initial requirements. So if the landlord complied with the initial requirements rather than an agent, then this extension doesn't apply.
Yes.
So you would have to say, would you not, that in retrospect, Mrs. Brown was the initial agent of the landlord.
I do have to, and I also have to make the point, none of this is the pleader challenge, of course, but yes, I do have to say that. The best we can do for these changes is draw attention to the explanatory notes that the court asked us to look at. I appreciate the usual caution about using what a civil servant thinks about it to change the position, but it's behind tab 34, I think, in the supplemental bundle. And it's paragraph 154. The problem seems to be that someone in government took the view that Regulation 2.1 as drafted didn't make it sufficiently clear that agents were always intended to be sufficient for this purpose. So they introduced the amendments that are now Articles 2, 3 to 5 to disapply the general provision on agency and to create a subcategory of agent who are deemed to be sufficient. What we get from that, respectfully I say, is that what the government wasn't trying to make any significant change by the amendments that were made by the Deregulation Act. It was trying to clarify the position, namely that an agent was always sufficient.
Well, it would be a very strange piece of legislation if Parliament were to pass retrospective legislation which invalidated something which had been valid at the time it was done.
Quite. Leaving aside normal principles of constitutional interpretation, one imagines many landlords would have a rather strong Article 1 First Protocol situation there, because they'd now be exposed to a damages claim that they were not exposed to at the time that they complied with it. Finally, just for completeness, I will say nothing more about it, but just note in our skeleton we also have grounds 2 and 3 in relation to our appeal on the deposit certificate, substantial compliance, and to same effect. There's nothing I want to say about that beyond what's in our written materials.
Yeah.
Might I just have a moment with Mr. Morris? My lords, unless we can help you with anything else.
Oh, well, thank you very much. That's a very convenient moment of break. All right, Mr. Heather, we'll hear you at 2 o'clock.